of Article 261(7), which affirms the position that an order under Article 261(6)(a) is intended for the institution of Parliament and survives the parliamentary term. Citing the final report of the Committee of Experts on the Constitutional Review, dated 11th October 2010, the court held as follows, I quote, "We ask ourselves, why did the Constitution deem it necessary to provide the default mechanism in Article 261? In our view, it was simply to guard against the legislative inertia or inaction, which would thwart or frustrate the full implementation of the Constitution. This is borne out by the first report of the Committee of Experts, which drafted the Constitution, where it was stated thus: the new Constitution also set out a procedure to be followed if a law was not enacted within the scheduled time. The challenge was to ensure that the new laws envisaged by the new Constitution are promptly enacted. Under Article 308 of the Bomas draft, if Parliament failed to adopt a particular law within the time stipulated in the table, anyone could petition the High Court for a declaratory order instructing Parliament to enact the law within a specified period. If this was not done, Parliament would be dissolved. The new Constitution followed the Bomas draft, the Bomas approach, in allowing the National Assembly to extend the time within which a bill is to be passed, provided that the extension is justified by exceptional circumstances and has the support of at least 2/3 of its members. It also permits any person to petition the High Court to deal with failure by the National Assembly to pass a law in time. If the National Assembly fails to abide by the court order, it will be dissolved and a new election held." End of quote. Our conclusion on this subject is that the order made in High Court Petition number 371 of 2016 transcended the 11th Parliament and remains a valid order capable of enforcement. Until it is complied with, the order bound the 12th Parliament that was then in session when the order was issued, and it still binds any subsequent Parliament, including the current Parliament. For this reason, it may still be transmitted to the Attorney General and the Parliament by the Registrar of this Honourable Court in accordance with Article 261(6)(b) of the Constitution, as read with Section 20H of the High Court Organization and Administration Act, in which event the timeline prescribed by the Court for Parliament and the Attorney General to take the necessary steps towards enactment of the relevant legislation will start running from the date of transmission. For these reasons, and the reasons that we have given, we allow the consultative petition against the advisory opinion in the following terms. The Chief Justice advisory dated 21st September 2020 is hereby declared unconstitutional, null and void. The Chief Justice advisory dated 21st September 2020 is hereby removed into this Honourable Court for purposes of quashing and is hereby quashed. An order of prohibition is hereby issued prohibiting the President of the Republic of Kenya from enforcing the advisory by the Chief Justice advisory dated 21st September 2020. Now, this being a public interest litigation, we make no orders as to costs. That's our order.
Thank you so much, my lords and ladies. We appreciate that very, very detailed judgment that has been delivered in time or schedule. We wish to just make a request that we may be supplied with the copies of judgment. I believe we also record that so that we can advise our clients. My lords and my ladies, on that last link where the registrar is being advised to transmit the order by Justice Matibu to the Attorney General, you're wondering whether that order can be made a bit express. clearly to the staff of the High Court to make that transmission.
Yes, we are sure that the registrar of the High Court will be able to read our judgment and act accordingly.
Unfortunately, they didn't read it when the team delivered, so we are just trying to be cautious.
Yes.
On behalf of the Speakers of Senate and Parliament, on the last thing of what my learned friend Mr. Wambola has requested, I think for neatness it would be appropriate for those orders to be sought in that specific file rather than this one, so that we can contain the proceedings within that file and not this one. These petitions were specifically to challenge the advisory